National ERISA Disability Attorney Nancy Cavey, and welcome to Winning Isn't Easy. Before we get started, I'm required to give you a legal disclaimer. The Florida Bar Association says I have to tell you that this podcast isn't legal advice, but nothing is going to prevent me from giving you an easy-to-understand overview of the disability insurance world, the games that disability carriers play, and what you need to know to get the disability benefits you deserve. So off we go. Over the last several episodes, I've been talking about the application process, what you need to know about the application, the work history form, the activities of daily living form that you'll fill out as part of the application, and that attending physician statement form that your doctor has been asked to complete. Now I'm going to switch gears, and we're going to talk about issues concerning notice, getting the disability claims form, filing your proof of claim form, because these are integral parts of the application claims process. But before we get started, let's take a quick break. Be back in a second.
Have you been robbed of your peace of mind from your disability insurance carrier? You owe it to yourself to get a copy of Robbed of Your Peace of Mind, which provides you with everything you need to know about the long-term disability claim process. Request your free copy of the book at caveylaw.com today.
Welcome back to Winning Isn't Easy. You ready to get started? Let's first talk about giving notice to your disability insurance carrier. Look, the initial claims process is daunting, and it's easy to make an inadvertent mistake that can delay or destroy your claim. Most policies require that you give notice to the disability carrier within a fixed period of time. Get out your disability policy. What's the amount of time that you have in which to give the disability carrier notice of your claim? Now, giving notice of a claim late does not necessarily have to be fatal, but I will tell you that the longer the time period is from the date you're claiming you're disabled until you actually file the notice of claim, the more likely the carrier is going to deny your claim on the basis of late notice. Ultimately, if this case ends up in federal court, there are some federal circuits that have held that the disability carrier has to prove that they were prejudiced by the late notice before the court will rule in their favor. Other federal circuits say, if you're late, too bad, so sad. So you need to know what your time limits are in your disability insurance policy. Now, let's talk about the practicalities and the strategy behind the timing of the notice. And I think there are at least 8 things that you should be considering that will impact this notice issue. Number 1 is whether or not you have had a discrete date of disability. In other words, have you had an accident? Or is this the progression of a disabling medical condition? If you've had an accident, it's pretty clear that the date of the accident is probably going to be the date of your disability. But let's say you have a progressive medical condition like Parkinson's, or you have MS. Now, you have been working perhaps while you've been disabled. You haven't lost any time, but as your symptoms are progressing, you have now begun to have difficulty doing certain duties, or your days may have been changed. I think the timing of the notice is a product of 8 different factors. So let's talk about each of these. The first factor is whether or not you have a discrete date of disability. In other words, did you have an accident? If you were involved in a motor vehicle accident, it's pretty clear that that's the date you have become disabled. But let's say you have a progressively disabling medical condition like MS or Parkinson's. You've been working while you are disabled, but as time is progressing, you're beginning to have problems with your occupational duties. You might reduce your hours, which can be a problem with coverage. And it's becoming clear that at some point in the near future, you're going to have to stop work and apply for your disability benefits. And so for me, an accident is pretty clear. If it's a progression of a disabling medical condition, it's not so clear, as I'll explain in a minute. Number 2, how well do your medical records document your symptoms and impact on your functionality? Is it necessary, particularly in a progressive medical condition case, to clean up your medical records so that they accurately tell the story of the progression of your disability? And that is going to play into number 3. If you have a progressive disability situation, the carrier is always going to question, well, why did you work yesterday, but all of a sudden you can't work today? So let me give you an example. I represent a dentist who has a herniated cervical disc. He's having tingling and numbness into his dominant extremity, which means that he is also having trouble doing different types of dental procedures and the number of procedures that he was doing on a regular basis. He's also had to reduce the number of patients he is seeing. Now, I have been asked to help him determine the date of disability. When I look at his medical records, there's nothing, not one thing in his medical records about what his disabling symptoms are, how they're impacting his ability to practice, whether he's made any modifications. All it talks about is he presents with tingling and numbness in his hand, into certain fingers. He's got muscle spasm, but not a blasted thing about his symptoms and functionality. If we were to apply for benefits today, the disability carrier would look at those records and say, why is it that Dr. X was able to work yesterday, but he can't work today? There's nothing in those medical records that explain what's happened. So we aren't going to be applying for disability benefits for a couple months because we have to cure the medical records. I call it document deficiency disease, DDD. We need to make sure that his medical records are documenting his symptoms and functionality and show a progressive slide out. And that's particularly true in his case because he has a residual disability claim, and we want to claim those benefits based on his lost income before we say, hey, there's a specific date we want to claim. Now, that's important, again, because there are some residual disability policies that require that you be totally disabled first and then collect your residual disability benefits. And that policy provision is going to impact when we pull the plug, if you will. Now, the fourth factor is whether or not your doctor supports your claim. If your doctor doesn't support your claim, isn't willing to document the symptoms and functionality, it's time to find another doctor. In the case of the dentist, I was able to conference with his doctors and explain why it is it's important that the doctor take a better history about my client's symptoms and the specific occupational problems he's having performing dentistry. The fifth factor, and one of the major factors in picking the date of disability, is the status of your employment and whether or not you think you might be terminated or laid off. Why is that important? Well, remember, I said that one of the considerations is why you work yesterday and not today. If you think that you are going to be terminated or laid off, I want you in your doctor's office being proactive and have you taken out of work before the inevitable happens to you. You can't explain based on your medical records why you worked yesterday and not today. So we do want to get that documentation. But more importantly, if your employment is terminated or you're laid off, you potentially are going to lose your coverage the date of that termination. If the doctor hasn't taken you out of work or you're not losing appropriate wages, that's going to be an issue because the carrier is going to say, hey, you weren't disabled the last day you worked because there's nothing in your medical records taking you out. You only became disabled after you were terminated. And guess what? You have no insurance coverage. Too bad, so sad. The sixth factor is going to be dealing with your health insurance coverage. Now, if you are able to go out on FMLA, you will continue to have your insurance benefits so long as you continue to pay those benefits. But at some point, your employment is probably going to be terminated. So you need to have an alternative for your group health coverage. Now, there are some employers whose policy allows for you to continue the coverage while you're disabled. But if for some reason your disability insurance claim is denied by the disability carrier, your employer is going to terminate your group insurance benefits. So it's important to have a plan B for your health coverage. The next factor is coordination with other benefits, such as state disability benefits. And this plays into factor number 8, which is your financial situation and the elimination period. Many disability policies will provide that you have to go through an elimination period, a period of time in which you get no benefits, but of course your bills continue. So the question is, financially, can you deal with this period of non-compensation for your disability benefits? And then that plays into, well, if you live in a state where there are state disability benefits, you might be able to be paid those state disability benefits during that elimination period or longer. So we always have to look at coordination of benefits, the the financial situation you find you're in, the elimination period, and how we can maximize all these other benefits. And the last factor is how long you've had the policy and whether or not we have any pre-existing condition issues. Let's say you just got hired by company A, and that policy says, hey, listen, we'll offer you disability insurance, but if you got treatment within a 90-day period of time prior to this coverage becoming effective, we're going to take the position that whatever that treatment got, whatever that condition is that you got treatment for, that's not going to be one of the disabling conditions that we consider. That is going to certainly impact any claim for disability benefits and the notice. So you can see that there are a number of factors that go into picking the right date to be disabled and the right day to give notice. In my view, it takes a team approach to pick the right date and to maximize your benefits and to cure any deficiencies that there might exist in your medical records. So take that all into consideration. I think it's time to take a break so you can digest this information. So we'll be back in a minute.